Ladies and gentlemen, welcome to my channel. My name is Uraya Chikwetu. I hope I find you well. In this video, I am going to share with you the key remedies for unfair dismissal under the labor law of Zimbabwe. But before I do that, I just want to say you may be new to my channel. I encourage you to subscribe to my channel and hit the notification bell so that YouTube can notify you whenever I upload a new video. For those who have already subscribed, I thank you for the support. Your support means a lot to my channel. Back to our business. What are the key remedies for unfair dismissal under the labor law of Zimbabwe? There are three key remedies, namely reinstatement, damages, and reemployment. In this video, I'm going to focus on reinstatement. Then in the next two videos, I will discuss damages and re-employment. Now we turn to the remedy of reinstatement. First of all, we need to identify the sources of legal principles concerning reinstatement under the Zimbabwean labor law. The sources are common law and statutory law, of which statutory law will focus on the Labor Act Chapter 2801. Then we turn on to reinstatement under common law. Reinstatement under common law. You also find that in terms of common law, there are at least two approaches, but the other one we are going to discuss it for historical purposes only. The approaches are the rigid approach, which is the old approach, and the flexible approach, which is the new approach. You find that the Zimbabwean courts or the Zimbabwean common law regarding reinstatement is heavily influenced by the South African common law, of which the South African common law is the Roman Dutch law. So, in terms of the old approach under the South African law, the South African courts has been the South African courts have been heavily influenced by English common law. In terms of the English common law, you find that the reinstatement was viewed as an order for specific performance, which was taken to be unavailable in employment contracts. That is under the South African old approach to reinstatement. The employee was only entitled to damages even if the dismissal has been unfair. There was, however, an exception with regard to civil servants, whose position was said to be regulated by statute, and any dismissal that was contrary to the requirements or the provisions of the statute was regarded as a nullity. This approach, where an order of specific performance was not available in case of employment of contracts entailed that employment contracts were in the class of their own. That is, in as much as the order of specific performance was concerned, the contract of employment would mean that it was in the class of its own, and whilst the other contracts where there is a breach of contract, the parties would be entitled to an order of specific performance. But under employment contracts, if there is a breach of contract whereby an employee is dismissed unfairly, the order of reinstatement was not available because it would entail an order for specific performance, which was regarded as not available under employment contracts. So the old approach or the rigid approach did not permit an order of reinstatement or an order for specific performance where there was unfair dismissal. This actually meant that if an employee is unfairly dismissed, he would contend with the damages. There wasn't a chance where an employee would be returned to his or her former job. Then we move on to the new approach. The new approach or the flexible approach under the Zimbabwean, under the South African common law. The South African courts departed from the rigid or old approach to reinstatement. And the first case to destroy the rigid approach with the view that employment contracts were different from the contracts so far as the order of specific performance was concerned was Stuart Rhinestone Private Limited versus Tope. In that case, the court held that just as in other contracts, specific performance was available in principle for breach of employment contract. That position was made clear in the case of National Union of Textile Workers versus Stag Packaging. In that case, the court held that there was no rule against specific performance, at least in employment contracts. Although in many cases specific performance will be refused due to the nature of the contract. Under this new approach, reinstatement was only available subject to the discretion of the court. Under the Zimbabwean common law, the courts have adopted the new South African approach, which means in Zimbabwe, the new South African approach is the position with regard to reinstatement under common law, which means that the order of reinstatement in Zimbabwe is available subject to the discretion of the court. The current common law position in Zimbabwe and South Africa is that there is no rule of law that reinstatement is not available in employment contracts. The courts have discretion, and in the exercise of the discretion, reinstatement will not normally be granted. There are appropriate cases where the court may exercise the discretion in favor of reinstatement. I think in the case of Zimbabwe, the case where reinstatement was opted for is found in the case of Commercial Careers College, 1980, Private Limited versus Jarvis. In that case, the court ordered the reinstatement of an employee who was a teacher or a tutor in an educational institution, and a number of factors were taken into account, among other things that the employee need not to maintain cordial relationship between cordial relationship with the managing director, because her job involved teaching students without frequent personal contacts with the managing director. Therefore, the court found that it was appropriate for an order of reinstatement to be granted in such a scenario. Even if the Zimbabwean courts or Zimbabwean common law adopted the South African approach, whereby the order of reinstatement is available in employment contract subject to the discretion of the court, it has been observed by legal academics that the order of reinstatement is largely unavailable in Zimbabwe, because the courts in various decisions are opting for damages as opposed to reinstatement. So why is such a scenario obtaining in Zimbabwe? We need to find out the reasons for outright denial of reinstatement and the discretionary granting of the order of reinstatement. We want to find why, what are the justifications? Why are the courts not in majority of cases opting for reinstatement? The reasons are, or some of the reasons are found in the case of Schneehout versus Minister of Justice. It's a South African case. The reasons that were enumerated by CJ Innes are that it was inadvisable to force one person to employ another whom he or she does not trust in a position that imports a close relationship. Then another reason the learned judge proffered is that with regard to the absence of mutuality, for the court could not by its order force a servant or a worker to perform his or her work faithfully or diligently. Then there is another reason that is also given as to why the courts are more inclined to declare payment of damages as opposed to reinstatement. One of the reasons is that it has been argued that damages are an adequate remedy, and also that an order of specific performance may potentially involve the oppression of the employee, which means there may be cases where the employee does not need to be reinstated, but the court grants such an order. It would mean that the employee will be working at the instance of the employer against his or her will. So those are some of the reasons why the courts have opted to grant damages in the majority of cases as opposed to granting an order of reinstatement. Then we move on to reinstatement under the Labor Act. You find that the provisions with regard to reinstatement are found largely in Section 89 of the Labour Act. And the import of the provisions under the Labour Act with regard to the remedy of reinstatement is that an order of reinstatement or a remedy of reinstatement can only be granted if it is accompanied by an option for the employer to pay damages. So this is the reading that one can obtain from that section. The order of reinstatement is granted where it is accompanied by an option for an employer to pay damages, which means that the labor court and the arbitrators have no power to grant an order of reinstatement that is not accompanied by an option for an employer to pay damages. So that is the legal position, or that is the import of the provisions in Section 89. So after having stated the legal position, we then need to discern or to establish some of the legal aspects that arise from the provision of the Labour Act with regard to reinstatement. One of the legal aspects that we find is to do with whether reinstatement is retrospective, whether reinstatement is retrospective. That is one of the legal aspects that we need to discuss concerning the provision of the Labour Act with regard to reinstatement. And then another legal aspect that we need to discuss is whether reinstatement is automatic. Then another legal aspect is whether reinstatement means that the employer have to provide work to an employee who has been reinstated. Then the other legal aspect is whether an employee can elect to reject reinstatement and opt for damages. Then another legal aspect is whether a reinstatement is available to civil servants. Then another legal aspect that we need to also discuss is the constitution and reinstatement. Then we go on to discuss the legal aspect on whether reinstatement is automatically retrospective. We can be able to answer that question by defining reinstatement. But you will find that the Labour Act does not define the word reinstatement. So we are going to employ the definition from case law, of which in our discussion, the definition we are going to use is one from Chegutu Municipality versus Manyora. In that decision, the court defined the terms to reinstate a person. To reinstate a person, I quote the court's decision, to reinstate a person means to put a person again into his or her former job. That can be done in the present or the future, not in the past. You cannot put him back into his job yesterday or last year. You can only do it with immediate effect or from some future date. You can, however, remedy the effect of previous injustice by awarding back pay and or compensation. But mere reinstatement does not necessarily imply that back pay and or compensation automatically follows. End quote. So from that definition, we can be able to pick that reinstatement means is not necessarily retrospective. To be retrospective, the order must specifically say so. So, from the definition, we are told that you can only do it with immediate effect or from a future date, which means that there is no retrospective application of reinstatement under the Zimbabwean labor law. The observation that has been done by some legal experts is that this position is wrong. Although it is law, it is regarded as wrong by some legal commentators, because in some jurisdiction, reinstatement is regarded as something that have got some retrospective effect. But the legal position in Zimbabwe is that it is not retrospective. It has to be granted in any order by the court. Then we move on to one of the legal aspects, whether reinstatement is automatic. Even if the order of reinstatement must always be given where an employer is given an option to pay damages, it does not mean that the reinstatement is automatic in every case of unfair dismissal. The order of reinstatement is still a discretionary order, which means it is the court that decides whether reinstatement is appropriate in a given case. And also, you also notice that from the reading of the Labour Act, there is no scheme for primary remedy. You find that there is an insistence of reinstatement or damages, which means that these remedies are equal, and the employer is the one who have got the right to choose which of the two will apply in his or her situation. And also you notice that if reinstatement is inappropriate, it is the employer who have the onus to prove that in his or her situation reinstatement is not appropriate, which means that the employer have to provide adequate evidence to demonstrate that reinstatement was not appropriate. Mere allegations will not suffice. There is need for adequate evidence to show that reinstatement was not appropriate in his or her scenario. Then we move on to one of the legal aspects, which is whether reinstatement means that the employer has a duty to provide work for the reinstated employee. The general rule is that reinstatement does not impose a duty on the employer to provide an employee with work to do. This simply entitles the employer to his or her salary, the employee to his or her salary and benefits upon tendering service. The general rule will not apply in situations where the nature of the employment contracts would require the employer to provide the employee with work so that he or she can be able to derive benefits that are contemplated by the employment contract. The fact that the employer has no obligation to provide work cannot be used to deprive the employee with the contractual benefits that goes with the office of the employee. Thus, the employee has the right to receive the benefits, even if they are performance related. The reason being that the employer is the one who is not giving the employee some work to do. This is the position that was taken by the court in the case of Standard Chartered Bank, Zimbabwe versus Matsika. In that case, the employee was reinstated without loss of salary and benefits from the date of his or her from the date of his suspension. The employee was entitled to school and boarding fees, was entitled to a car, was entitled to entertainment, and also was entitled to some share of profits of the bank. The employer or the bank paid the employee his salary, but withheld some of the benefits. One of the arguments that the bank or the employer gave was that the benefits were discretionary and performance related. And for example, the bank said that it cannot give the employee the car because it was meant for the employee to travel from home to work, and in their case, the employee was not being provided with work, hence he cannot claim the car. And then with regard to entertainment, the bank argued that the entertainment was meant for clients, and since the employee was not being given work, there were no clients to entertain. The bank, the court did not agree with the bank and ordered that the bank pay all the benefits or provide all the benefits to the employee because it was not supposed to benefit from its omission of not giving an employee work. So the bank was asked to provide all the benefits by reason of the fact that it was the bank that was not providing the employee with work. Then we move on to one of the legal aspects on whether an employee can elect not to be reinstated and opt for damages instead. In terms of the decision of the Supreme Court in BHP Minerals versus Takawira, the employer has an option to choose to pay damages rather than reinstating the employee, or the employer can choose to reinstate the employee as opposed to paying damages at the same time. But the employee was not similarly placed, which means that the employee cannot choose to be paid damages where the employer has chosen reinstatement. The court laid the law as follows. An employee cannot choose without justification to refuse reinstatement and demand damages. The employee must have good reasons to refuse reinstatement. Where an employee refuses genuine offer of reinstatement, he or she abandons the claim of damages in respect of the period after the reinstatement was supposed to commence. So from that court judgment, an employee cannot elect to be paid damages where the employer has already chosen that he wants the employee to come back to his or her job. This position is correct where an employee has initially asked for reinstatement and changes his or her mind after the order of reinstatement has already been granted. An order of reinstatement or damages has already been granted, and the employer has opted for reinstatement. So once the employer has chosen the remedy he or she thinks to be appropriate in his or her circumstances, and where the employee has initially chosen reinstatement, and the employer has opted for reinstatement, the employee cannot run away from that, because the employer is given the right to choose among the two of the remedies. But this position does not mean that the employee is prevented from opting for damages at any stage of the dispute resolution process before a final determination has been made. So the reason being that under common law, the innocent party in any action of breach of contract is entitled to pursue a remedy of his or her choice. The Labour Act has not altered that legal principle. Then we move on to the legal aspects, with regard to whether civil servants are entitled to reinstatement. The Labour Act does not apply to public servants or public employees. The position of civil servants is regulated by common law, and common law has always been favorable to the public servants. So the legal position is that the civil servants are not entitled to reinstatement per requirements of the Labour Act. Their position is governed by common law, and this is so because the common law has created an exception to its rule denying specific performance in employment contracts to allow reinstatement of unlawfully dismissed civil servants on the basis that they are regulated by a particular statute. Then we move on to one of the last legal aspect, which is the reinstatement vis-a-vis the Constitution. Some observation that has been done by some legal experts or constitutional law experts is that there is a possibility that the approach provided for in the Labour Act, whereby it prevents a court to grant reinstatement as the only remedy in appropriate cases, may face a constitutional challenge. The challenge may arise from the possible allegation that the provisions of the Labour Act violate Section 65, subsection 1 of the Constitution, which provides for a right to fair labour practice. The legal experts argue that such a challenge may depends on the meaning of the concept fair labour practice in Section 65, subsection 1 of the Constitution of Zimbabwe, 2013. The arguments the constitutional and legal experts proffer is that fairness demands the striking of balance between the interests of the employees and those of the employers. But from the observation that they have done, the current position is that the interests of the employers are being pursued at the expense of the interests of the employees. Fairness demands that the employee and the employer, at the very least, are afforded the same treatment, which means that there is need for the courts to be bestowed with the power to order reinstatement as the only remedy. Because as we found from the provision of the Labour Act, the employer is given more rights compared to the employee with regard to reinstatement. The Labour Act requires that every order of reinstatement must be accompanied by an order for an option for payment of damages by the employer. And from the reading of the case law we have done, we found that an employee cannot make an election as to whether he wants to be reinstated, where the employer have chosen reinstatement. Which means that there is no equal treatment or benefit before the law, because the employer is availed more rights as compared to the employees, and the courts are compelled to offer an order which must offer a guilty party an option to choose from one of the remedies. In fact, an order by the court against a party that is guilty of breach of contract must be something that is painful. So the employer cannot be availed more rights when he or she is the guilty party, and the employee who is not guilty or the innocent party is refused an option to choose between the two remedies that will be available. So I think the challenge, the constitutional challenge, if it happens, it may be able to discuss some of the points that we have raised here. So I think this is the position with regard to the remedy of reinstatement. So the conclusion we can give is that under the common law of Zimbabwe, reinstatement is available subject to the discretion of the court. And in terms of the Labour Act, reinstatement is supposed to be granted, but it must be accompanied by an option for an employer to pay damages. The courts, the arbitrators have no power to grant an order of reinstatement that is not accompanied by an option for an employer to pay to pay damages. So this is the position. Just to say, I encourage you to subscribe to my channel. If the information that I have discussed in this video is interesting to you, you can like the video and offer your comments in the comment section so that we can further ventilate the issues. I thank you so much. I meet you in the next video, where I am going to discuss the remedy of damages. Thank you so much for your time. May God bless you.